A federal court in Texas just dealt a major blow to the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Federal Judge Reed O'Connor ruled that central provisions of the ATF's 2022 Frame and Receiver Rule violate both the Second Amendment and the Due Process Clause of the Fifth Amendment. This was not a narrow procedural technicality. The court did not merely hold that the agency botched its administrative paperwork. It ruled that the federal government failed the constitutional test entirely, concluding that building and repairing personal firearms is conduct directly protected by the Bill of Rights. The ruling comes in Defense Distributed and Second Amendment Foundation v. Todd Blanche and the federal government, issued out of the Northern District of Texas, Fort Worth Division. It marks a critical turning point in the years-long legal conflict over homemade firearms and parts kits. Before reaching the historical debate surrounding the right to bear arms, the court addressed a fundamental due process problem. The ATF wrote a criminally enforceable regulation so ambiguous that ordinary citizens cannot determine when they are breaking federal law. Under the Fifth Amendment, the government cannot enforce penal rules without fair notice. A statute or regulation is unconstitutionally vague if it fails to clearly define prohibited conduct or invites arbitrary enforcement by federal authorities. In its 2022 final rule, the ATF expanded regulatory oversight beyond finished firearms to reach partially complete, disassembled, or non-functional frames and receivers items the agency determined could readily be completed, assembled, restored, or converted. To evaluate readiness, the ATF outlined 8 factors, including time, ease, expertise, equipment, parts, availability, expense, scope, and feasibility. Then came the structural flaw. The agency designated those 8 criteria as a non-exclusive list. Consider the practical reality. At one end of the spectrum sits raw metal or polymer. At the other end sits a fully finished, functional firearm receiver. Somewhere between those 2 points, the government claimed that an unfinished object crosses an invisible legal line and transforms into a regulated firearm. The court demanded to know where that line exists. Judge O'Connor concluded the ATF failed to provide an objective answer. The determination of when raw material becomes a regulated firearm was left entirely to the agency's subjective discretion. As the opinion noted, determining when an item crosses that threshold devolves into essentially guesswork and intuition. Because the rule fails to provide clear legal boundaries to the public, the court struck it down under the Fifth Amendment as void for vagueness. Yet that due process finding was only the opening strike. The decision then dismantled the regulation under the Second Amendment. When the plaintiffs argued that restricting unfinished components directly infringes upon an American's ability to build and maintain personal firearms, the government countered that the rule does not ban gunsmithing outright. Federal attorneys argued it merely applies standard licensing, serial numbering, and background checks to necessary parts. Judge O'Connor applied the constitutional framework established under Bruin. First, does the plain text of the Second Amendment cover the individual's conduct? The court pointed out a decisive detail. Both parties agreed that making and repairing firearms falls under the Second Amendment. That meant the conduct is presumptively constitutional, and the government's attempt to restrict it is presumptively unconstitutional. From that moment, the entire burden shifted to the Department of Justice. The government could no longer lean on public policy arguments, ghost gun crime statistics, or claims of administrative convenience. Under constitutional precedent, the government had to prove that its restrictions match this nation's historical tradition of firearm regulation. To justify its restrictions, the federal government pointed to colonial-era inspection laws from Massachusetts and Maine that required gun barrels to be tested and marked for structural safety. It also cited early municipal regulations governing the safe storage and transport of commercial gunpowder. Judge O'Connor rejected every one of those comparisons. Applying the Supreme Court's historical framework, the court examined both how and why those early laws burdened the public. Colonial barrel-proofing statutes were narrow product safety measures designed to keep defective barrels from bursting in a shooter's hands. Early gunpowder laws were basic fire prevention codes aimed at stopping massive accidental detonations in crowded population centers. The ATF's modern rule serves an entirely different purpose. Its objective is criminal tracking and deterrence, executed by placing federal licensing, serialization, and retail background check requirements on raw parts, build kits, and ordinary workshop tools. Because the regulatory purpose and legal mechanisms are completely different, the court held that early safety inspections bear no resemblance to the ATF's sweeping component bans. The historical record went even further. The court found that the government's position directly contradicts the nation's actual tradition of private firearms manufacturing. From early colonial settlement through the founding era, self-reliance in firearms was an economic and defensive necessity. When the British military moved to disarm the colonies in 1775 and 1776, revolutionary leaders responded not by regulating workshops, but by actively urging local blacksmiths and citizens to produce their own firearms and bayonets. Colonial militia statutes routinely required able-bodied males between the ages of 16 and 60 to furnish their own weapons that frequently had to be made by hand due to a lack of commercial arms makers. Throughout the entire 17th, 18th, and 19th centuries, spanning 3 full centuries of American history, the court found no record of laws restricting individuals from building firearms for personal use. This was not a complete loss for the federal government on every technical count. Judge O'Connor turned down the plaintiff's claims under the Administrative Procedure Act, finding that the ATF had adequately explained its change in regulatory policy. The court also acknowledged the Supreme Court's 2025 ruling in Bondi v. Prime Vanderstock, which established that Congress did grant the ATF statutory authority to regulate certain partially completed frames and receivers. The critical distinction is that statutory authority cannot override the Constitution. While the agency may have statutory jurisdiction under the Gun Control Act, the specific enforcement measures under 27 CFR Section 478.11 and Section 478.12c fail under constitutional review. The resulting legal relief is precise. Under the precedent set in Trump v. Casa, a single federal district judge cannot issue a nationwide injunction striking down a rule for all citizens. Instead, the court entered declaratory relief, finding the challenged provisions unconstitutional and void for vagueness, accompanied by a targeted permanent injunction. The federal government is permanently barred from enforcing 27 CFR Section 478.11 and Section 478.12c against defense. Distributed the Second Amendment Foundation and all current and future members of the Second Amendment Foundation. Specifically, the injunction shields Defense Distributed's M1000 911 frames, G80 build kits, unfinished frames, unfinished receivers, and grip modules from federal enforcement. The ruling does not vacate the entire rule nationwide, nor does it override state-level bans on unfinished components. The core consequence of the Fort Worth decision reaches far beyond a single line of parts kits. By establishing that the Second Amendment protects the manufacturing and repair of firearms rather than just final possession, the ruling sets a firm constitutional barrier against federal attempts to regulate the components of home gunsmithing.